As regards whether the government has a standard protocol of consulting the authorities of the intended receiving countries before proceeding with the deportations of foreigners, the short answer is there is no such standard protocol. As stated in my ministry's reply on the 2nd of July 2024, foreigners who are being deported can leave for any country to which their passports allow them to go to. The foreign country can, as a sovereign state, choose to allow entry, or it can choose to disallow entry when the person arrives on its shores. Or it can take subsequent actions to expel the person after entry. And that's the way we treat these persons is no different from any other traveler. We do not consult foreign countries beforehand as a general rule as to whether a traveler is allowed to go there. As regards Ms. Lim's second specific question, the general position is that we do not disclose specific discussions. Discussions may sometimes take place for operational security reasons, for intelligence reasons, other similar purposes. But since this particular question seems to interest the Member of Parliament, because she asked last month and followed up with several supplementary questions, and now again, I will say no, we did not discuss with the Cambodians or the Cambodian authorities. But having made that position, for future, let me make it clear to Members of Parliament, the general position that my ministry takes about discussions with foreign governments on deportations is that we should not be disclosing this. It's not in public interest to disclose it because there are a variety of reasons why we may be in touch with foreign governments, and likewise we may want people to be deported from foreign governments as long as the law allows it, and we sometimes will not want that publicly disclosed upfront. Later on, the facts may come out. Otherwise, the others who are collaborating with such persons of interest may then get wind. So these are sometimes matters of operational security. But here, in answer to the question, no, we did not discuss with the Cambodians.
Thank you, Deputy Speaker. I have two supplementary questions for the Minister. First, I accept that there could be some operational considerations and not revealing too much information, so I'd like to say that up front. I'd like to ask Minister, because it was indicated in this House that offenders are permitted to indicate their choice of jurisdiction to where they would like to be deported. So my question is the Ministry concerned that the offender would tend to choose a jurisdiction which he considers to be favourable to him, and by that I mean that he might be concerned about possible prosecution for the predicate offences, which led to the money laundering, for instance, and would that be something that the government would take into account, that he may choose a jurisdiction that would actually facilitate his avoiding prosecution for certain other crimes that he may have committed overseas? So that's the first question, whether the government is concerned about this in giving the offender the choice. And secondly, I wonder whether the Minister could confirm or not whether the choice of deportation country, is that part of the plea bargain process?
On the whether offenders can choose to go to where they want to go, we have said it several times. They can choose to go to where they want to go. The law allows them to go where their passports allow them to go to. So what we think about what will happen to them in the receiving country, whether it will be more favorable or less favorable, as Ms. Lim will appreciate, is legally irrelevant. And it's not something that the government can take into account. Second, as regards the choice of deportation and whether that's part of the plea bargain process, again, strictly speaking, if the offender the person who is asked to leave can choose to go wherever he wishes to go to, then the relevance of it becomes small. I don't engage in plea bargains. That's a matter between AGC and the defendants' lawyers. I cannot rule out that these discussions take place, but I can tell you what the legal position is.
Earlier, Minister mentioned that what might happen in the jurisdiction that is chosen is legally irrelevant, but I'm just wondering whether he will agree with me that, money laundering being an internationally transnational in nature, that, we would also like to be seen to be doing our part to ensure that the offenders face justice for whatever offences they have committed. So as such, are we not interested in whether, the likelihood of such offenders facing prosecution or being charged for any predicate offences that they may have committed overseas, and to that extent, we should play our part as well?
Well, in the first place, they would have served time in Singapore if they have committed an offence here. Second, of course, we are interested, which is why we are the chair of the FATF. We take this very seriously, but it's wishful thinking to think that every other country will take the same approach, or that we can control how other countries can or cannot operationalize their legal position. If you were to ask any country, they will all tell you that they take it very seriously. And we should not be making those value judgments. However, rather than engage in this back and forth, Ms. Lim may be aware that we have amended our legislation last year such that once it's operationalized, which should be sometime later this year or next year, the law will allow us to decide where to send such a deportee. But the only consideration cannot be what we think of the different legal systems. There has got to be a multiple set of considerations.